morning.
Good morning, everybody. That was a terrible intro since it said April 20th on that. But hey, welcome to WGL AM. I'm William Kirk, joined again by Kostas Moros from the Second Amendment Foundation. Good morning, Kostas.
Good morning. And don't worry, William, other than the Gardner denial, they may as well watch last week's. It'll probably be the same.
That's true. And of course, we are joined by Miss Hannah Hill with the National Association for Gun Rights. Good morning, Hannah.
Good morning, Bill. How you doing?
I'm doing well. You are having another fantastic hair day, by the way. And Hannah and I are both in South Carolina now. We're about an hour from each other?
Hour and a half, specifically.
About an hour and a half, yeah. And I'll be heading that way in a couple of days to do some work with NAGR. Okay, real quick, let's get you up to speed while we wait for the orders list. Like, you guys haven't done this a million times with us already. Here are our 5 usual suspects: Duncan, Gators, Viramontes, NAGR v. Lamont, Grant v. Higgins. The first 2 are magazine bans. The last 3 are semi-automatic rifle bans. To let you know that if this feels like Groundhog's Day to all of you, yeah, it should. This is how many conferences each of these cases have had. Duncan is now on its 13th. Gators and Viramontes is actually on their 12th. The Gators is a misprint there. Grant and Higgins almost nearing 10. And guys, if by chance we end up with a nothing burger, we got 2 conferences coming up, one next week, one on the 14th. So we may be back at this again. Predictions, Hannah, any predictions today?
All right. So my Irish ancestors have me in full superstition mode. I'm scared to make a prediction. The minute I predict something one way or the other, it's going to happen the wrong thing. So I'm just holding my breath at this point.
Well, I was talking, Kostas, you and I were talking before we went live. You got any predictions for today? We think we're finally getting to the end. I mean, this is about as far as Snopes went before we finally got answers.
Oh, yeah, man. They're going to grant everything, and they're also going to undeny Gardner and grant that, too.
They're going to undeny Gardner. They're going to undeny Gardner and do it with a per curiam, right?
Yeah, totally. By the way, I just checked, and Snope had 15 conferences before.
15.
Oh,
I knew that was like a... Now, I will tell you what made that more painful when I went through that last year is I was doing it by myself. So this year, I've gotten to do this with you two, so it makes it far more tolerable. So thank you very much.
Misery loves company.
Misery loves company. Exactly.
We'll all drink the Kool-Aid together after this is done.
Yeah, exactly. All right. So we are about 1 minute out from the orders list coming out. If we got a nothing burger, we'll rant and rave about the nothing burger, and we'll talk about a few other things. Miss Hill has to get rolling just before the top of the hour. She has other important things to deal with today, and we won't go too long if we end up with a nothing burger. If we get a grant, we'll have a little celebration. And if we got denials, if it's on Duncan, as you know, we'll have to pull Kostas off the stage for a few minutes just to be safe. Let him go ahead and smash things up, and we'll go from there. All right. Did you guys have good weekends?
Yeah.
I did. Yes. Beautiful weather in South Carolina. It's not great weather today, and we're supposed to get some rain and everything, but the weekend was great, Bill.
It was. I spent it all in a car. In the last week, I have driven from Murfreesboro, Tennessee to Lynchburg, Virginia to Charlotte, North Carolina, Charlotte, North Carolina to Columbia, South Carolina. Then I'm going to Greenville, South Carolina, too. So we got about 1,200 miles on that rental car already.
And that's a beautiful road trip coming down that way.
It is. And the people are wonderful. And my trip out to from Murfreesboro to Lynchburg was a 7.5-hour trip. And I stopped along the way. I shot one video outside Neyland Stadium at the University of Tennessee, shot another video outside the Bristol Motor Speedway in Bristol, Tennessee. So that was kind of cool. All right. I'm refreshing my page. We don't have an orders list yet. It's up. Here we go.
Oh, there it is.
All right. All right, so this is where we start doing word searches, everyone, on the orders list to see what we can find. No Duncan.
Looks like another nothing burger unless they only granted some or something. Or denied some. I meant to say definitely not granted.
If it tells y'all anything, I'm way more worried. No,
And for those of you who don't know, the cases that are granted are listed right at the very top of the order. Okay, so you know which ones are granted. Then all the cases that got turned down are listed below that. And if you do a word search and your word doesn't show up, Duncan doesn't show up, that means it has not been granted, it has not been denied, and we just roll it over to next week, I guess. I don't know. What do we got so far, guys?
The other case I checked, Viramontes, no Duncan, no Grant. No, was there one I'm missing?
Gators.
Gators, that's right. There's no way it got, yeah. So another nothing burger.
well, y'all, if it means anything, I'm clearly
With all
I'm
these
way
nothing
more
burgers,
worried
I
than
can stop
hopeful,
taking.
So I'm actually relieved at this point. I mean, look,
I know. You know what's going to happen is we're like the boy that cried wolf, and eventually when we do have action, we're going to have like 5 viewers online when this happens because everyone's going to it's going to be another nothing burger.
To be fair, we're never hyping it up as like something's going to happen.
That's true.
We're pretty honest.
Because we have no clue.
That's true.
We're here
We're
just
all
in case
equally
something
depressed.
happens, but yeah.
I will point out there was another 922G3 case got denied. That's U.S. versus, I don't know how he pronounces it.
Is
but
it Nandoro?
No, Doucet, Doucet. That's a
And that's a G-
922G3 case. We kind of wondered if that would get a hold for Hamani.
Well, you know, that's interesting you bring that up, Hannah, since we're going to, I guess, now move on to our morning scramble since we don't have anything else to talk about. But as you know, we had found that there was these 2 922G3 cases that had conferenced a while back and been put on ice. It was the Harris and the Sam case. I found a third one, this Nyandaro versus the United States, which also conferenced back December or January or something like that. This again is a cannabis case, and it's been sitting there with no activity since. So I think we got 3 cases that are on ice awaiting the rulings out of Hamani, but I'm a little surprised to hear that this other one just got shot down.
So am I. The question was whether or not it was a predicate conviction for attempted cultivation of marijuana. Interesting. Very interesting.
Yeah, it's a slightly different fact pattern. Normally we got the user, right? The guy who likes to smoke a little weed and owns a firearm. This is a person who's actually a grower.
What's really funny too is that we have a state legislative candidate who is apparently funding his campaign in South Carolina off of an illegal marijuana business, allegedly. So,
Jeez, what party is he or she running from?
Republican, of course.
A Republican?
It's a deep red district. Yes, and he got arrested. Anyway, this is not
where's the op at? Is it in South Carolina? The grow op?
Well, I think.
What's the problem? He sounds awesome.
Well, except it's illegal and he's running for state house. Like if he's in jail, he's not going to get to serve. So that's the biggest problem.
Okay.
Only if the grow op's in South Carolina. I mean, the grow op could be out in Oregon or something like that. You know,
just tell me if you tell me he also doesn't pay taxes, I'm going to be totally in love. I'm going to come campaign for this guy.
That is, Kostas is going to be writing him a campaign check later today.
Unfortunately, whatever they rule in Hamani, I don't think is actually going to help him.
No, probably not.
Unfortunately, so. You know, I think he's actually importing it from Missouri. I think it's what's happening.
Well, you can't grow in Missouri either, can you? I mean, the only states that allow growing weed are like out in where Kostas and I live, where then it's like, you know, no problem. Let it rip.
I think it's more legal, less illegal, if that's a thing in Missouri. I don't remember exactly.
I don't know.
They might put him under the jail.
Yeah. Real quick, everyone. This is the welcome, but don't get too comfortable. These are all cases that I found. Don't need to do a search because I already know what happened to all of these. These are all cases in which a petition was filed. The respondent waived the response that was granted, and they were set for conference right away. I am guessing that all of these are history.
Actually, Tabor survived.
Tabor survived. You notice how I had that one highlighted?
Yeah.
That one has a couple little interesting wrinkles. We don't need to get into it now, but I actually had highlighted that one because I thought that was the one that maybe had a chance. I'm not saying it has a real chance of getting accepted, but it definitely has a chance.
Also survived.
Huh?
Tong survived. At least I'm not seeing it in today's list.
Okay.
Are you sure these were conference for today?
Yeah.
Okay.
Okay.
Taylor.
Taylor.
It was the only one denied, right?
Taylor got shot down?
I believe
No,
so,
no,
yeah.
actually, never mind. It's Jermel Taylor v. Washington City Jail. So no, none of these got ruled on. Are you sure
Okay.
they were conferenced
That's
for
not
today?
okay.
Yeah, they were listed
Oh,
as conference
interesting.
for today. Interesting. Okay.
Maybe they just didn't
All
get to
right.
that category yet.
So-
That's interesting.
One of my guys is messaging me that Tabor is a 5-1 conference. So
Oh, it's a 5-1
that might be
conference. Okay.
That might
So we
be
get
why.
to talk about that next week.
Yeah.
Okay. Okay. Do you want to know what else just got petitioned before the United States Supreme Court? I had an opportunity to read the petition. You guys heard of this case?
yes, indeed.
Yeah. That sits before the United States Supreme Court now. Now, this is an interesting challenge because this is not a traditional Second Amendment challenge. This really has to do with a lot of irregularities in the trial record as well as in the indictment itself. To give you an idea of what the issues are, whether an indictment satisfies the Fifth and Sixth Amendment when it charges possession of a machine gun or destructive device, when the indictment does not allege the facts necessary to bring these items within the statutory definition of the crime. There's also another issue is whether a court may uphold an invalid indictment on the ground that the defendant could have sought a bill of particulars, notwithstanding this court's settled rule that a bill of particulars cannot save an invalid indictment. If the indictment's invalid, the dumbest thing that a defense attorney could do would be to ask for a bill of particulars and actually allow them an opportunity to tighten it up. And then finally, whether the Fourth Circuit erred in summarily dismissing the petitioner's as-applied Second Amendment challenge based on nothing more than an erroneous circuit precedent on which there are multiple circuit splits of authority on questions presently before this court. This is a case that has captured the attention of the entire Second Amendment community. And for those of you who are not familiar with the Adamiak case, I strongly encourage you to check out every article that Lee Williams has written about that. I don't know if any journalist has covered this case more frequently. Hannah, you and I have had an opportunity to talk about this on a couple of different occasions.
Yeah,
Kostas, have you done? Go ahead, Hannah. Yeah. What were you going to say?
we're going to be doing an amicus brief on this case.
Oh,
That's
awesome.
currently in the works. Yeah.
Awesome.
Kostas, you've
Kostas,
been-
have you?
Yeah,
I've
yeah,
been- I've been
we have a
Adamiak.
brief coming as well. And
Beautiful.
obviously Lee is part of SAF's investigative journalism project.
Mhm.
And I mean, look, the hard truth is the Supreme Court's almost certainly not going to grant this case. And we're
Right.
doing an
I agree.
amicus brief to give it our best shot. But what really needs to happen here, and I hope I'm wrong, I hope the Supreme Court either grants it or holds it pending a hardware case, because I think this is relevant to a hardware case. But what really needs to happen is President Trump needs to pardon this guy.
It needs
Trump
to
has
happen.
pardoned a lot of losers and a lot of people that probably don't deserve it, and he should pardon Adamiak.
I
you know,
wholeheartedly
just
agree
because-
with Kostas'
Here.
sentiment there that for the people that have been pardoned, and it's not unique to Trump, every president
Yeah,
pardons
of
a bunch of
course.
people, and
Mhm.
some of them totally deserve it, and some of them you're like, really? You're going to pardon that person? But Adamiak is so deserving of a pardon because
He
even the
is.
people who are supporting the conviction, even the people who don't think there's any irregularities in the conviction, when they look at the sentence, and this is very united across the board here, the sentence was absolutely insane.
You're right.
Insane. And there was a lot of irregularities where the court relied on information that wasn't even admitted at the trial to enhance the penalty. And there's all sorts of things going on there. So that's a case that we're going to start carefully watching. I'm going to get Lee Williams back on the channel. For those of you who've never heard Lee talk, Lee is a wealth of information. He's a pretty interesting character on top of it. He's a fantastic writer. So actually in the description box after we're done today, I will find the links for Lee Williams stuff on Adamiak, and I'll link it up. So for those of you watching on replay, you'll be able to check it out in the description box. Another case, guys, you remember this one? Johnson v. New York. This is a case where Johnson was found to be in possession of a firearm but didn't have the proper licensing as required by the state of New York. He's arguing that, well, at the time that I would have needed to apply, there was still that good moral character, which was thrown out by Bruin, and I would have never been able to get through the good moral character the way you were implementing it. The case got petitioned to the United States Supreme Court. Letitia James asked to waive the response brief. Supreme Court said, no, we actually want to hear from you. And that case is coming back on for conference. And Kostas, let me ask you first, a case that goes back and revisits Bruin and something like that, do you think that increases, decreases, or has absolutely zero effect on the likelihood of it being accepted?
It probably, look, anytime they're going directly against precedent, there's a chance that it increases the chance of being granted. Unfortunately, the odds of cert grants are so rare that I'm not sure how much it matters. You know, it's so narrow. So we'll
Just
see.
one
Hannah,
thing.
have you? Yeah, go ahead, please.
So with a case like this is actually ripe for DOJ involvement. It's not new facts. It's enforcing what the previously plowed ground for the Supreme Court. This is actually the sort of thing that the Department of Justice's Second Amendment Division does like to get involved in. So I'll be watching for an amicus brief for them to weigh in on this. And that, of course, as we know, does change the game a little bit in terms of the calculations the Supreme Court's making. So it's going to be very interesting to see if they bypass this one or if they jump in.
So another new petition that's kind of interesting. I don't think it's going to get accepted. It's Mislow versus the United States. The issue is whether military courts of criminal appeals have the authority under 10 U.S.C. 866 to correct an unconstitutional firearms ban annotated after the entry of judgment. Here's the issue in a nutshell. You can do things as a private citizen that may be illegal, but won't get you disarmed. But if you do those things as a member of the military, you will get dishonorably or less than honorably discharged from the military, and that will disarm you. Even though as a private citizen, that exact same criminal activity would not have disarmed you. And that was the appeal that that Mislow made in that case, and the military appellate court said, we don't have the authority to fix this. We literally don't have the jurisdiction to fix this. So away we go on that issue, and it's going to be interesting to see where that one goes. Don't think it's going to actually be accepted by the court, but it will be interesting to see what kind of traction we get on that.
So this is a jurisdiction case. This is not a Second Amendment case.
Correct. Yeah, kind of a venue question. Right.
Well, the Supreme Court likes those better than Second Amendment cases, so who knows?
Yeah.
That's how better it's called I am.
Well, listen, we got to get going here in a few minutes. For those of you who just tuned in, thank you very much. We appreciate you all being here, all 390 of you that are live online right now. For those of you who are watching on replay, hey, thanks for joining us for yet again a healthy dose of nothing burgers. Duncan, Gators, Viramontes, Higgins, and Lamont we haven't gotten an answer on any one of those. They were all presumably rolled over to this Friday. It'd be really nice if the court just kicked these things like a month down the road. Right, because the likelihood that we're going to have some significant change week by week by week, as we know, is gonna not.
Yeah, I'd really love to talk to a clerk one day about why they do that. Like, why list it ever? Just take it off until you're ready to do something and then list it. You know, like they've done with the 18 to 20 cases. I don't understand this weekly relist thing. You know, there must be some category, and that's why a lot of people say they're probably going to be denied with a dissent because that's what they usually do. But I still don't understand why we have to drag this out.
Yeah, I mean, it would seem like, in the February conference, if they decided, hey, we're a ways away from really being able to resolve this, that they could have just set it for an April conference. You roll this in. Just like as a trial attorney, when you're in court and you're asking for a continuance, the judge will ask, like, how much time do you need? If you need, well, we need about 30 days, Your Honor. Well, you're probably getting a court date about 45 days out then.
Well, this week, if they do go to another conference, Gators moves into a tie with Snope, and Duncan is one behind, I think, for the 15. Did I say 14 or 15 realists for Snope? Anyway.
Well, 14 for both of them, according to Bill's count.
Well, I think that actually Gators and Viramontes are on 12 today.
Oh, okay.
Duncan's on 13. So Duncan will move to 14. Gators and Viramontes will move to 13. Grant moves to 10. Congratulations, Hannah. Grant is Grant v. Hig, NAGR v. Do I got this all screwed up? Yeah. What a terrible slide. Let's take that piece of crap down right now. But NAGR's case is going to move to its 10th conference now. So we have only one in single digits at this point.
Which if honestly though, when I pull up that order list and I'm doing the first word search, it's always Duncan now that I'm searching for. If that tells you anything.
They rise or fall with Duncan, I think, unless for some weird reason the court doesn't like magazine cases, which is possible. Right. So, because Duncan is only magazines. So,
but let me ask you this, Kostas: if they don't like magazine cases, why the hell would they take an assault weapon ban case then?
Well, look, I agree. I think you could argue it both ways because there's one category that says, well, AR-15s are scary, but these, magazines aren't because it's just, your standard Glock mag, big deal. But I could also see it the other way with, somebody saying, well, AR-15s, that's just cosmetic bans, but magazines are what's deadly, you know, because they have the extended capacity. So I've long been afraid that the most John Roberts thing ever, I think I've said this before, would be to strike down AR-15 bans, but uphold magazine bans. Like
It would be the most John Roberts thing.
yeah,
ever.
yeah, he would love
John
that. Like,
Roberts.
just like make no one happy, compromise. Like that's his
We would
whole
all be so
MO.
unhappy, and the left would be equally unhappy. It would just be a bad day around.
Yeah, yeah, everyone would just
And
be
then
angry
Roberts
at him.
would be tickled pink then.
Yeah, he'd love it. Oh my
Well,
gosh.
he'd go on vacation immediately after that, and he'd be laughing from his.
But yeah, I've heard arguments from both sides on which is supposedly scarier than the other, but I don't know. I think I hope anyway, the reason if Duncan doesn't get granted despite its record, it could either be that they don't want magazines or that they want to decide the issues together with a case that deals with both of them. You know,
I mean,
like
the one thing that's happened since we all did this last week is that en banc review's been granted in the DC Magban case.
Oh, there it is. We were going to talk about that. Good segue, Hannah Hill.
Yeah. So the question is, well, will that make a difference to the Supreme Court's calculations?
Well, that's an interesting question. What do you think, Kostas?
I don't think so. I mean, look, it was great to go have everyone tell them, hey, there's a circuit split now, and now, of course, the other side saying, well, there's not anymore. You know, I don't know that they cared that much about Benson. Maybe if it was done for sure, but honestly, if the Supreme Court was going to grant Duncan until en banc got granted, then they're so full of it because they know that how this works at this point with the lower courts and how anti-gun they are. So I think I posted on Twitter that the fact that it got granted is reason to, or that en banc got granted is reason to grant certiorari. You know, the fact that these lower courts keep reversing themselves whenever they reach a decision that upholds Second Amendment rights is reason to review this. But you know, who knows? I don't think. I think they're waiting on the Third Circuit, frankly.
At that time and time again, in the various petitions we've filed at the Supreme Court, and so far it has proven unpersuasive.
Yeah.
But you're right. I mean, the unanimity of the defiance of both Bruin and Rahimi at this point, and Heller, should really be the biggest reason to take it. I don't know why they don't.
Well, and they've had a couple of other opportunities in years past that they could have done it as well. So that again, and as I did a video last week, and I could, after last week's morning conference that we all did, and just looking at the comments and things, and especially with Gardner getting shot down, the frustration level amongst the 2A community is significantly increasing. And I get that sometimes the 2A community can get a little fickle and get a little too worked up about things that maybe you don't deserve to get as worked up about. They can do that sometimes. But I have to kind of back them up here on this one, that this frustration with this Supreme Court at least appearing to not want to do anything about this. You know, there's some stuff to back up those sentiments now at this point.
Yeah, I mean, I think the court is destroying confidence in themselves if they don't act on these. I mean, the Gardner denial was disappointing last week, but at least you could say, it's an early case on this. Maybe they want more percolation as they always do. But there's nothing to wait on the hardware cases. Like, we've had plenty of rulings. We know, as Justice Thomas said, the lower court seemed intent on defying Bruin, at least the ones that hear assault weapons cases. I don't know what's happening. I mean, they're holding 5 cases now. It's going to be a real bummer if all they're doing is denying all of them with a dissent. You'd think they could just deny the rest of them and hold whatever one somebody's writing a dissent on. You know, like, I don't know why we're playing this game.
Yeah.
So if I were more optimistic, I would say this looks like somebody's writing a per curiam opinion, but I know better at this point than to be hopeful about something like that, because it is a little strange to hold 5 cases for one dissent, you know, especially when a couple of them are in a preliminary injunction posture. But they did that last year with Ocean State Tactical. I think they held it.
Was Ocean State on a prelim also?
I believe it was. My memory might be failing me, but I believe it was. And that was one reason I was hopeful, because I'm like, well, they wouldn't hold a PI case if they're just going to deny Snope. And yeah, they did. Yes, they did.
And they did.
Denied it.
Exactly that.
Held it. So,
which makes you wonder if, honestly, they even know what they're going to do. we assume they have a plan. They might not have a plan.
Yeah, it could be, and that's it maybe they'll hold Duncan or others over the summer. That's unlikely, but it could happen, and that would be the sign that they're waiting for the Third Circuit. Unfortunately, I think the Third Circuit's waiting for Wolford and Hamani just so they don't get GVR'd again. So even though they're not related to hardware.
So we may end up, if they're waiting for Wolford and Hamani, which are both likely to come out May, June, right there, then we may get Cheeseman sometime, and then we got a summer where we're just sitting around, which we also may have some change in potential change in the Supreme Court bench, although that's not for sure yet, but there's rumors about that. So it could be a big summer of waiting, and then we start this whole exercise of futility all over again in the fall.
I think the thing you have to remember, and this is true of all of us, the three of us, I think, but when you sign up to work in a form of politics for a living, and the judicial branch is also political. They like to pretend it's not, but it is. When you work in politics for a living, you sign up for the heartbreak, and there are a lot more losses than there are wins. And you have to step back and you have to see it from a historical perspective. Our nation has had some dark times, and there are times when worse laws have ruled in our land for longer periods of time. And it took literal blood to get rid of many of them. And the job of a patriot is to keep going when you've lost time and time again. You pick yourself up and you keep going and you keep fighting. And historically, over the last 250 years of our nation's history, that always pays off. That gamble always pays off. That persistence pays off. And to those who were discouraged, I would just say you haven't left bloody footprints in the snow yet. So maybe get some perspective.
Those are very wise words, Hannah. And that's now that we got Hannah's wisdom out there, I'm going to ask both of you about something here real quick. I was just out in Tennessee, and while I was out there, they passed House Bill 1847. This permits the use of lethal force in defense of property.
Like
Hannah,
in Texas at night.
It was not meant to be a segue, Bill.
what do you think of that as a policy?
Well, from a policy perspective, I find it hard to argue with.
Okay.
It's one of the top three: life, liberty, and property. And if you're not allowed to defend your property as an American,
You are allowed to defend your property. This allows the use of lethal force to defend your property.
to think about it, to tell you the truth. I would hesitate to myself. Do I think it should be wrong in all circumstances? Again, just initial knee-jerk reaction. It's hard to argue with a policy perspective. However uncomfortable I would be with that priority analysis in actuality. That's the best I got for you at the moment. I had to think about that one.
Yeah, no, I've been doing some soul searching on it too. Kostas, what's your gut reaction? I'm not going to hold you to this because obviously we can evolve on issues, but when you first heard about it, what'd you think?
I'm not against the idea of using firearms to protect property in all cases, but I think you got to be careful into what we're talking about here. Like, is a shop clerk going to shoot some teenager because they stole a thing of gum? Like, you know, that it depends. I think the context matters a lot. You know, if a burglar's in your house, I like the idea because I don't want there to be an argument of, oh, he was just taking property. And
but if a burglar's in your house, you already have the right to use
castle doctrine
because you have a felony. Because you have a felony being committed inside your home. So this is someone's trying to break into your car, or this is someone's trespassing on your property.
I think what I meant to say is more like that. More, not I know literally inside your house means the castle doctrine applies, but I mean sometimes it's on your property. It gets into a gray area, and I think that's where this is useful. And sometimes, you know, in a riot situation, for example, or looting, I think it's totally fine. You know, that's different. They're going to destroy your store, destroy your livelihood. That's a lot different than some kid being dumb. You know, so it's very context specific. I'm not against it in all cases, but there are times when, you know, I think lethal force would be excessive in particular situations. Yeah.
And in fact, in most situations where they would apply this doctrine, it probably would be excessive. I mean, we've seen some of those news stories, and it makes it easier because a lot of times the home-based self-defense cases, the property and the person defenses converge, right? You're defending your home as well as your life, so you don't have to ask those questions. But when it gets harder, the farther from your own home that you get.
Yeah. My concern on it, and I'm not against it, but my concern is as a criminal defense attorney doing trial work, I have met some people who, for lack of a better term, were looking for a reason to shoot somebody.
Yes.
Okay. And you know, kind of vigilante wannabe. Very, very limited number of people. It's very, very, very small minority. But one of the cases that I had to work on through a national organization one time was a person who lived in a kind of a rough neighborhood, and his car was constantly getting prowled, and he was getting sick and tired of it. So one night he decides to leave the garage open with the car in it, knowing it's going to get prowled. And when 3 kids walk in to start prowling his car, he walks into the garage with his shotgun, and his exact words were, "It's showtime."
Oh, Jesus Christ.
And he let him have it. He let him have it. And then during his trial, his defense team actually decided to put his wife on the stand so she could describe what she heard and saw. And of course, it came out. What did your husband say when he walked into the garage? I just heard him say, "It's showtime," and then boom, 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 boom. Now, obviously, that person ended up going away on that one, but I question whether or not this law in Tennessee would potentially contribute to that kind of behavior. And I just think it's something that, you know, maybe should have been thought through a little bit. The governor is going to sign it. Even if the governor tries to veto it, trust me, the bill, bless you, the votes in both chambers of Tennessee will override that veto. So
yeah, and look, on the flip side, there could be positive consequences from it, which is that criminals hear about this and don't do as much crime.
That's exactly right. No, because it serves as a deterrent effect. You want to go to Tennessee and commit crime, you can get yourself killed.
Right.
That's
just come to California. We don't stop criminals.
Hannah Hill, you got to get rolling, don't you? You got a meeting in a couple of minutes. Okay,
yes,
listen, we'll get going. Kostas, any last words you want to say before we let everyone go for this morning?
See you for next Groundhog's Day next week.
Yeah, exactly. We'll be back next Monday. For all 406 of you online right now, thanks so much for tuning in. We don't have anything but a big nothing burger today. We anticipate they're going to be relisted for conference on Friday. If they are, we'll be back with you on Monday. If not, we'll be back on May 17th after the next conference. Hannah, I'm going to give you the last words for the day. Anything else you want to say before we roll?
Yeah, just that the Supreme Court could announce opinions on Wednesday morning, so we should keep an eye on that.
Wolford
watch. Good point. Yeah. We could get Wolford. We can get Hamani. Probably Wolford's going to come out before Hamani.
Probably
don't we agree?
Yeah.
Wolford's an easier case too. So
and it was already sooner.
Yeah,
I agree. Okay. Well, listen, on behalf of Kostas and Hannah, thank you everyone for tuning in for our Nothing Burger special once again. If the cases are relisted for this Friday, we'll be back on Monday. If they actually get rolled over to the May 14th conference, we will probably be back on the 17th of May. In the meantime, all of you stay safe. Have a great work week. And you too, thanks so much for joining us again this morning. I really appreciate having you here. Thanks, guys.
Appreciate it.
All right. Have a good day.